Breaking news. Welcome to today's headlines. Kanu approaches court to enforce fundamental rights. Kanu approaches court to enforce fundamental right. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. Detained leader of the indigenous people of Biafra will today at the Federal High Court, Umaya, be opening proceedings on a 25 billion naira suit against the federal government of Nigeria over his illegal extraordinary rendition or forceful expulsion. The matters which comes up before Justice Evelyn Anyadike is filed by the special counsel to Mazi Nnamdi Kanu, HIPOB, Aloy Ejimako leading a team of other lawyers. Recall Justice Anyadike recently delivered a ruling invalidating a certain of the amended electoral law. In a press release signed and issued by Barrister Ejimako and made available online to the press, entitled Nnamdi Kanu approaches Federal High Court, Umaya to enforce his fundamental right against unlawful expulsion, Nnamdi Kanu will be seeking many reliefs, including but not limited to redress of his forceful expulsion, but also an apology from the Buhari government and special and general damages caused of 25 billion naira from the same government. The full text of the release and the summons read thus. Today, 25th March 2022, on behalf of Mazi Nnamdi Kanu, I am leading a team of lawyers at the first hearing of the fundamental right enforcement suit I had brought before the Umaya Division of the Federal High Court. The matter lies before Justice Evelyn Anyadike. The suit is sui generis and primarily aimed at redressing the infamous unlawful expulsion or extraordinary rendition of Nnamdi Kanu, which is a clear violation of his fundamental right under Article 12(4) of the African Charter on Human and People's Rights. In addition to the rendition, I am asking the court to redress the myriad violations that came with the rendition, such as the torture, the unlawful detention, and the denial of his rights to the fair hearing required by law before anybody is expelled from one country to the other. You will recall that on 19th January 2022, the High Court of Abia State determined that portion of violation of Kanu's fundamental right that occurred in 2017, even as I had made claims that bordered on rendition. The court declined jurisdiction on grounds that rendition being related to extradition lies within the exclusive jurisdiction of the Federal High Court. So, this instant suit is as a result of my considered decision that a fresh action before the Federal High Court will be the best route towards addressing this matter of rendition or unlawful expulsion and its legal impact on the prosecutorial powers of the Nigerian state. To be sure, the extraordinary rendition of Nnamdi Kanu triggered legal injuries that cut across multiple jurisdictions, both inside Nigeria and abroad. There are now no legal and even diplomatic issues that must be addressed in the United Kingdom, Kenya, the United Nations, and the African Union. And within Nigeria, the rendition has expanded the matter far beyond the realms of the trial that lies in Abuja. I would like to seize this opportunity to express my profound appreciation to the highly competent and professional team of lawyers that I am leading in the aggressive prosecution of this complex suit. Special mention must be made of barristers Patrick Agazi, Ohaito Uwazi, and Mandela Umedborogu. The specific reliefs I requested in this suit are as follows. 1. A declaration that the arrest of the applicant in Kenya by the respondent agent without due process of law is arbitrary, and the respondent enforced disappearance of the applicant for 8 days and their refusal to produce the applicant before a Kenyan court for the purpose of applicant extradition is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against arbitrary arrest, to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. 2. A declaration that the detention of the applicant is a non-official secret facility in Kenya and the torture of the applicant in Kenya by the respondent agent is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against unlawful detention, torture, and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let us know what your view is all about. Thank you for listening.